Welcome, everyone. I'm Aisha Pioti, and it's my great pleasure to have you with us for the third day of our 2022 AI Policy Summit. During the course of the last 2 days, we have actually listened to fascinating exchange of views on how we can balance innovation with building trust in AI, using policy as a tool. We have also explored not only the implications of AI within the justice system, but also how we can harness the power of AI to improve the lives of people, especially in the developing world, including in Africa, Middle East, and in India. Today, we'll be turning to the third theme of our summit, which is AI and democracy. Today's program features 2 panel discussions, one on the interaction of AI with democratic values and fundamental rights, and the other on AI and democratic engagement. We will have also an interactive session with MEP Axel Voss from the European Parliament on the EU AI draft, starting today at 5 p.m. Swiss time. Now, I urge you to check out the full agenda of the conference on our website, which will give you a complete overview of all the discussions for today as well as for tomorrow. Tomorrow, during the hybrid day of our event, we will explore the last 2 themes of this year, which are AI and the future of work, and how we can build bridges between regions and stakeholders to ensure that AI serves us all without infringing on our fundamental rights. Now, for those of you who might be joining us only today, I wanted to also share again some of the remarks I had shared at the kickoff on Monday to give some context to the discussions that will follow. When we started our journey together 3 years ago on this project, our vision was to build a global discussion platform that leverages on the Swiss culture of inclusiveness and transparency, our excellence in research and innovation, and our unique credibility in the geopolitical space to build trust and maximize the adoption of AI. Our idea was to bring leading multidisciplinary experts from around the world to share their experience and knowledge with the Swiss AI ecosystem on AI policy, and of course, also to explore the role we can play to achieve our common goal of building trustworthy AI. I'm delighted to inform you that we feel humbled to have made great strides in achieving some of those initial goals. For our summit this year, we have registered participants from 81 different countries, representing every single continent except Antarctica, a clear testament to the global interest in this topic. Our global community of experts is also ever growing. During this week, you have the chance to listen to and interact with policymakers, business leaders, academics, innovators, and representatives of civil society from around the world. Now, based on the feedback from our last 2 events, it became clear to us that whilst raising awareness and increasing engagement on AI policy was an area we could clearly contribute towards, it was equally important that we broaden the geographic inclusiveness of this dialogue. So the agenda for this year's summit reflects this feedback. In addition to latest developments in the EU and the US, this year's summit features expert contributions from India, Singapore, various countries in Africa, including Tanzania, Egypt, and Kenya, and from Mexico and Brazil in Latin America. For today's theme of AI and democracy, I'm particularly excited to have an incredible set of speakers representing the Swiss government, the Swiss Parliament, the OECD, IBM, Future of Life Institute, Meta Oversight Board, AlgorithmWatch, Center for AI Digital Policy, as well as Diplo Foundation, to ensure a truly inclusive debate. I will now pass the floor to my colleague, Professor Elliot Ash, from ETH Zurich Center for Law and Economics, who can also share a few thoughts about this year's event from his perspective. Elliot?
Thank you, Aisha, and thanks to all of you for joining, not just today, but the last couple of days, which is very interesting, and hopefully see you tomorrow and perhaps later. I'm Elliot Ash. I'm a professor at ETH Zurich Center for Law and Economics. As some of you saw a quick preview of yesterday, my work uses data science and economics to understand human as well as machine decision-making, in particular in the case of judges and the law. At the Center for Law and Economics more broadly, we have a diverse group of researchers exploring the legal and economic aspects of technology and policy. We also work with the ETH AI Center on the Legal Tech Initiative of regulatory issues. I'm happy to help represent the academic side of the collaboration underlying this AI Policy Summit. Our goals are to understand how policymakers and entrepreneurs make decisions and to help support such decisions, in particular about AI. At ETH Zurich, we think researchers should contribute not just to technology of AI, but also the policy of AI. If you're interested in the academic side of these issues, I recommend the upcoming workshop in AI plus economics, which is starts on Friday and is organized by my colleague Sergio Galletta. We have an in-person event on Friday and Saturday, and it will also be streamed online. So please check out the website to register for that and get the link. Thanks again for all joining today, and back to Aisha.
Thank you, Elliot. Now, before I introduce the next session, I just wanted to remind our audience that our event offers a unique and neutral platform for people representing different walks of life to discuss in an open and respectful manner, as well as to find solutions. And your views are very important for us, and we wish for these discussions to be as interactive as possible. So please do participate in the Q&A sessions, use the chat functions on Zoom, and help us to ensure that your voice is heard. Please also note that as a participant, you will get access to all follow-up summaries, as well as selected recordings of the sessions. Lastly, we'd be very happy if you shared your impressions of the AI Policy Summit on social media, mainly on Twitter and LinkedIn, using our hashtag AI Policy Summit 2022. I will now pass the floor to Merve Hickok from the Center of AI and Digital Policy to kick off our very first panel discussion of today on AI, democratic values, and fundamental rights. Merve, the floor is yours.
Thank you so much, Aisha. Thank you, Elliot. It's great to be here. I'm really honored to be part of this great conference as well. So let me start by introducing our panelists first. Not that any of them need any introduction, but I still want to go ahead and provide a very short intro. My name is Merve Hickok. I'm the chair and research director at Center for AI and Digital Policy. CAIDP is a global think tank with education, advisory, and advocacy pillars, with a mission to ensure AI and digital policies promote a better society, more fair, more just, more accountable, a world where technology promotes broad social inclusion based on fundamental rights, democratic institutions, and the rule of law. So hopefully that makes sense why why I'm hosting this and moderating this panel. But I'm really excited and honored to be joined today by some fantastic panelists. And let me go ahead and provide you with some details about their background and experience and why they are some amazing people to be talking about AI, democratic values, and fundamental rights today. Thomas Schneider, Ambassador and Director of International Affairs at the Swiss Federal Office of Communications. He's a long-standing expert in digital governance and in the governance of information and knowledge society and AI. Since 2020, he is the Vice Chair of OECD's Committee for Digital Economy Policy and Vice Chair of the Council of Europe's Steering Committee on Media and Information Society, which he chaired from 2018 to 2019. Thomas Schneider, since the beginning of this year, is also the chair of the Council of Europe's Committee on AI. Angela Mueller, she's the head of policy and advocacy at AlgorithmWatch and AlgorithmWatch Switzerland. Angela manages AlgorithmWatch activities at a national and international level. In Switzerland, she's responsible for entire policy advocacy work for the organization. In addition, she covers horizontal regulations, particularly the work of Council of Europe and the EU's AI Act. Mark Rotenberg, President and founder of Center for AI and Digital Policy. He's a leading expert in data protection, open government, and AI policy, and has served on many international advisory panels, including OECD AI Group of Experts. Mark helped draft the Universal Guidelines for AI, which is a widely endorsed human rights framework for regulation of AI. He's also the author of several textbooks, including 2020 AI Policy Sourcebook and Privacy and Society book. He teaches privacy law and GDPR at Georgetown Law. Next, we have Jean-Marc Leclerc. He joined IBM's Government and Regulatory Affairs team in 2015, where he coordinates IBM's engagement on EU policy issues. Jean-Marc is the chair of Policy Committee at the Business Software Association and chair of Digital Economy Committee at the American Chamber of Commerce to the EU. Before joining IBM, he was policy director at Digital Europe between 2013 and 2015. And last but not least, Celine Caira. Celine is an AI economist and policy analyst at OECD. Before joining OECD, Celine worked as senior policy advisor to the Canadian Federal Minister of Innovation, Science and Industry, where she provided strategic policy advice to the minister on issues including innovation policy, COVID-19 economic recovery, and vaccine biomanufacturing, foreign direct investment, intellectual property, and more. Celine has worked across federal, provincial, and municipal governments, NGOs, and multiple United Nations organizations, including World Intellectual Property Organization. As Aisha mentioned, we do want the discussion to be as engaging as possible, and would like to remind you that we're looking forward to your participation. So I'll try to engage your questions as much as possible, and also make sure that I leave time at the end to further conversations. But without further ado, welcome to my panelists, and I'd like to kick it off. I don't know, good morning, good afternoon, or good evening, wherever you are. It's 4 a.m. where I am. I had to do a last minute travel, so apologies if I'm looking a bit sleepy today as well. But with that, let me start with a round question, and I would like to get some feedback from all of our panelists. When we say fundamental rights, rule of law, it's easier to list those, enumerate those, but when it comes to democratic values, it's not so easy. One, it is not every country is a democracy, but even within democratic countries, there is always this conversation of what it is not. So I would like to ask each of you what your understanding is of democratic values. And the follow-up question would be, what would be considered some infringements and impact on democratic values from your perspective? And maybe Angela, I kick off with you, if you don't mind.
Okay, thanks. Yeah, thanks a lot for the invitation. Thanks for having me. And also hello to my fellow co-panelists. It's great to be here. Yeah, big question to kick it off, but very important one, of course. I think it's important to say that what democratic values is not only is a procedure of the majority deciding over minorities, because there's much more to democracy than that procedural aspect. I think there are substantial preconditions on which democracies are built. And of course, fundamental rights and the rule of law, what you just mentioned, are among these substantial preconditions. But what does that mean? Fundamental rights try to protect human dignity, human autonomy, human freedom, but also considerations of justice. So, the majority deciding over the minority also includes substantial preconditions as to how do we protect minorities, for example. So I think this is important to say that democracy is much more than a procedure. It is really substantial values, as you said, behind it. And I think especially when we talk about the use and governance of technologies, it's important to say, it's not just about finding some majority decisions, but really about compliance with these values in the first place, so that this equips us with the means to really democratically design governance frameworks. And for that, I think it's important that this is a debate in which we all participate. It's not a debate where only data scientists can participate, but it's really a debate about rights, about power, about autonomy, justice, and so on in our society. And I think we need everyone at the table for that. Thank you.
Thank you. And thank you for kicking us, Angela, for being the first one to go. Celine, can I get to you? What is your understanding of democratic values?
Sure. Thank you, Merve, and hello, everyone. And thank you, Merve, for waking up so early for this important discussion as well. So indeed, a big question, and I agree with so much of what Angela said. But maybe I'll answer this question from the perspective of the OECD, and also provide a little bit of context around what the OECD is and its interesting historical background. So, the OECD was born out of World War II from the Marshall Plan for the reconstruction of Europe. And it was based on a consensus vision that policy matters and better policy can indeed lead to better lives. And these countries that came together, we have 38 countries, they're democratic market economies with shared values. And how that relates to the question of democracy, and particularly how democratic values relate to AI, that really manifested, and we'll get into this more in the discussion today, in 2019, when experts came together and it culminated in the OECD AI recommendation, which was at the time the first intergovernmental standard on AI. And so this kind of embedded values, including democracy, and including it aimed to create a definition of AI, which is an incredibly difficult thing to do, which again we'll get into on the panel, and it essentially espoused principles in how AI actors should respect the rule of law, human rights, democratic values, but throughout the AI system lifecycle. And building off what Angela said, to be more specific, these are fundamental rights like freedom, dignity, autonomy, privacy, non-discrimination, and fairness are some that we hear. And so infringing on these rights gives rise for the need for safeguards in the context of artificial intelligence. And so, concretely put, this could mean the capacity for human review of a decision made by an AI system, or transparency and explainability into what we call the black box, for instance. So these are just some opening thoughts, but we'll get into it more. So I'll leave it there. Thank you, Merve.
Thank you for your comments, and we'll definitely get in. Thomas, maybe I jump to you next.
Yes,
what is your understanding of democratic values?
Thank you, and hello to everybody, and I'm happy to be with you. Well, let me challenge my Swiss compatriot and say that for me, democracy is definitely not mainly majorities deciding over minorities, but it's basically the idea that people have the right to self-determine how they live, to the extent possible, to the extent that whatever they do and decide has no negative impact on others. And so that does not necessarily always have to mean that 51% decide over 49%. There can also be consensus decisions that are taken, so that you discuss as long as until everybody is willing to accept the decision. And of course, that implies several elements like the right to take an informed decision. So to know what you're deciding about, the right to also review a decision, and in particular, of course, what is very important for us in this country, in Switzerland, is that you have the subsidiarity principle. So it's the question is who takes what decision. So it's not necessarily the whole country that has to decide over every detail of where people live in a valley and how they live their lives. So the principle of subsidiarity, that those take a decision that are actually affected by it, and not necessarily others that are not affected by it, that can be culturally or even economically. So there are several elements of democracy. Of course, some binary decisions have to be taken yes or no, but most of the time it's in the gray zones where you try to live up to the expectations of different ideas, of different views in a society about how to live. So I would say it's definitely much more than a majority ruling over a minority, but it's trying to give everybody the possibility to decide him or herself about how they want to live. I'll stop here for the time being. We'll probably get to it later.
Thank you so much for that. Mark, I would like to jump to you. What is your understanding?
Well, it's a great question for us because, of course, when we launched our report on artificial intelligence and democratic values, we began with an assessment of what we meant by democratic values. And we looked at certain characteristics like public participation and transparency, independent decision-making, protection of fundamental rights. There are 12 characteristics, in fact, in our report on AI and democratic values, and we've used that to evaluate countries' AI policies and practices. But in fairness, I have to say, particularly living now in Washington, maybe our list was incomplete because, of course, a critical requirement for democracy is the peaceful transition of power. And a couple years later, I think I would add that one to the list as well.
Otherwise, why don't we just, I'll take over. I think we should just continue. So maybe we can, at this point, maybe bring in Jean-Marc. Are you there? Jean-Marc Leclerc? If you can perhaps...
Yeah.
Oh, yeah, there you are, Merve. We lost you for a second.
I lost internet. I'm sorry.
Oh, okay. All right. Well, glad that you're back.
I'm doubting whether to ask Mark to repeat, but I'm not going to go have the entire audience to go through it again. But let me go to Jean-Marc and continue from there. And apologies for that.
Hi, Merve. Hi, everyone. It's great to be here. Thanks for the invitation. Well, I think the colleagues have said a lot of right things there. What I would say is, and they've listed all the, what we generally understand by the democratic values and the type of rights that come out of these values historically. And I completely agree with Angela and the other participants that it's not just about procedures, although procedures are important because procedures mean laws and how we protect those rights, enforce those rights that come out of the democratic values that the colleagues have listed. And it's interesting to have the conversation at the moment, especially here in Europe, where we have some tensions around some of those values or how they're interpreted. We have this debate, I'm sure you're following too, on the rule of law in Europe and how there are different interpretations of the values and how some of those values or the rights that come out of those values can, well, sometimes maybe clash or have different interpretations. If you take the freedom of speech and the democratic decision making on one hand, and on the other hand, you have equality, inclusiveness, the independence of the justice system. So these are all values and rights from those values that are a bit clashing in Europe at the moment, very much between governments. It's an interesting debate. But to put it back in the context of technology and AI, I think it's the same thing. The challenge to me may not just be about what the democratic values exactly are. We can have endless lists, but more how the rights which historically emerged out of these values and in some countries were adopted constitutionally can be protected when they are challenged either by other interests. Some would call them greater interests, broader interests, or interests of the general public, and with technology in the middle of that mix. So that's really the question I'm I'm interested in as well. And maybe I don't know, it's a personal opinion, but it's very much the Western debate. I mean, being from Western Europe myself, it's embedded maybe naturally in my DNA what I think are democratic values, because I've just been swimming in it all my life. Is it the same on other continents, in other cultures? I'm not sure, but there's definitely, I think, a cultural element to this.
That's why I wanted to kind of ask the question as well. And to your point, Jean-Marc, even without the technology, we are having enough problems protecting the fundamental rights, rule of law, and democratic values in different contexts. And adding emerging technologies or technologies with great speed and impacts on great and speed and scale adds a whole different element of it. I want to kind of continue with you on the next question, though. You coming from a corporate background, private background, what would you consider within all this challenges with technologies, especially on AI? What do you consider the role of corporations in protecting these values, or should there be a role?
Oh, there definitely is a role, or should be a role, but I think this role is already there, because I see this very much linked to in the context of technology, to the broader topic of trust and trust in technology. Because I think, if you look at the market, and I hear my colleagues mention this more and more, I think we've moved from wanting technology that just works to technology that not only works, but which can also be trusted. And so I think more and more companies understand that they have, how could I call it, a moral objective as well on top of commercial objectives. But by the way, these moral objectives can serve commercial objectives, and maybe this sounds bad, but I think that trust is now a business. The more trustworthy you are, probably you'll do better on the market as well. So there's an interest as well, a commercial interest to be trustworthy, if I can mention it like this, on the market. But and this is all about the ethics in the world of technology. So companies, I think, are more and more expected to prove that they are responsible, and that what they put on the market, the technologies that they put on the market, can be trusted. So I think it's been a journey. IBM and other companies, I think, have started with principles. But now the point is, one, to put those principles into practice, because we can have theoretical conversations about this for hours, but I think more and more society expects to see this in practice. And also how, as a company, we can advocate for government policies that align with these principles and these practices. And so the whole thing is to, I think, for companies to embed this ethical thinking into what we do, into our governance structures. It's not just on the products. It's how we talk about it and enforce those ethical principles throughout the company, from developers to sales to communications and marketing. It has to be across the board. I can give you a few examples if I can take one more minute on that. This journey from principles to practices. In the context of AI in particular, I think we were one of the first companies to establish an ethics board. That it's not just a few high-ranking executives sitting in a room and discussing ethics. It's about a board that actually has a power. When, say, for example, and I have a good example in the context of the COVID crisis, when developers in the companies come up with a project which can have some risks from a from an ethical perspective, this board is consulted and has a say on this. And when we were, at the hot moments of the COVID restrictions, you had to balance that, and we've had quite a few instances where the board was consulted with questions such as, we would like to help this government with this COVID pass, or that kind of technology. Are the guardrails that we have in the software enough to protect people's privacy, their health data, cross-border transfers of data? Do we have the right safeguards? This type of question. This goes to our ethics board. So it's a board with operational value and competence. So this is just.
I hear that you're kind of looking into the living the transition.
Yeah.
Into making the trust, as you mentioned, trust your business, and trying to make that possible. Angela, I would like to switch over to you. AlgorithmWatch has been looking at a lot of instances where governments use this AI technologies or corporate technologies. Coming from your angle, from where you see it, is there a role, or should there be a role for corporations in protecting the fundamental rights and democratic values?
Thanks a lot for the question. Traditionally, fundamental rights are something the individual has towards the state. That is the traditional concept of fundamental rights. I think today it's clear that the obligation to respect, meaning not to violate fundamental rights, is something that also binds private actor. Clear, it's not legally clear. So there's a huge debate going on business and human rights. But I think there is some common understanding on that. At the same time, obliging corporations also to protect fundamental rights against violations by third actors, or to oblige them to work towards fulfilling fundamental rights, is also of course, partly dangerous move, because we don't actually want actors to be charged with these very important tasks and obligations that have other interests beyond serving the individual, that have their particular private interests. These are institutions that are not democratically governed or governed by the rule of law. So I think that's important to have in mind. It's not just the concept of fundamental rights cannot, as such, just be adopted for corporations too. Of course, they always set important limits and should be the benchmark against which we assess conduct. But I think that also means we cannot depend on the developer, for example, of an AI system to make a system fully compliant and ethical and responsible by design, because I think there's a limit to what you can do also at the technical level. On the one hand, because the risks that come with the systems also heavily depend on the context of the use of a system. And so that's not something you can really consider at the technical level, or not fully consider. But also because I think we should not have to rely on, say, the goodwill of private actors. Of course, it's great if they adopt self-regulation and so on, but we should actually be able in a democratic society to rely on our legal norms and to rely on them being enforced by institutions that are in compliance with the rule of law. So I don't mean that, initiatives by corporations are not important, and we definitely need that, and we definitely need that debate. But at the same time, we should be aware of where the limits are, and that it's actually us as a society that should be the ones setting the governance frameworks within which the corporations can then offer their products and services, and we can use the system. Thank you. I see that Thomas has a comment on that.
No, I would like to go to Thomas. As I hear you, you mentioned two things. One, rights for the corporations, and then the second piece was self-governance. It should not be rather self-governance, but we should be setting the expectations and the requirements from the corporations. ensure that these rights are protected, the rights of the individual and democratic values is protected. But Thomas, let me go to you and hear your intervention.
Yes, thank you. I just wanted to react to some of what has been said. Of course, we all know that there are these the RegHorizon principles, the UN guidelines on business and human rights. But as Angela has just said, and we know that there is a number of self-regulatory frameworks based on principles that companies give themselves. But of course, there's also legislation in every country that basically gives a framework to businesses, what they are allowed to do and what they are not allowed to do. And this is also nothing new with regard to AI. Such regulation comes with every technology. So you have when it's about aviation or cars or health instruments, you have safety regulation, you have consumer protection regulation that gives a framework to what businesses are allowed to do or not to do. In some cases, you also have like competition regulation in the sense that it's not allowed to make false promises or give false fact about a product or a service that you're selling. So there's a number of regulation that there is, and of course, with all countries in Europe that have, and this is different from those European countries that have signed up to the Human Rights Convention of the Council of Europe, states have positive obligations to protect not just consumer rights, but basically human rights of their citizens, and they are bound to develop a regulation that protects the rights of their citizens also against infringements by private actors. And if you're not as a citizen, you think that your rights are not protected, you may sue your government for not protecting your rights. So this system is now 70 or a little bit more than 70 years old now, and it's quite working quite well in countries outside Europe. There is not there's not such a court like we have in Europe, but there are other ways, the constitutional rights to some extent at least, that people can enforce their rights or at least have some ways to work on businesses to respect their rights. So it's depending on the country, it may differ, but normally there's quite a sophisticated system of regulation that at least to some extent respects and helps people that businesses also respect their human and other rights. Thank you.
Yeah, absolutely, Thomas, and I totally agree. We're not inventing the wheel again and again, and it shouldn't come as a surprise when we're talking in the context of AI that we're also looking at regulations and in terms of protecting fundamental rights and protecting the rights of the citizens, and to a certain extent the communities as well. I think there's also work to do in maybe expanding that definition for the communities, but that's another conversation. Mark, what would you like to contribute to this discussion?
There's a positive way to understand the relationship between the protection of rights and the role of the private sector, and that is to think about the way in which innovation occurs within the context of a good legal framework. Certainly, this has been the experience through the era of environmental protection, where regulations forced companies to be more efficient in their production and more respectful of the environment. And we see that today with the production of electric vehicles. It's regulation that oftentimes enables innovation. And we see this in the digital space as well, with new technologies that help protect privacy and allow people to engage in commerce and communication without the risk that a lot of personal data would be disclosed to others. So, properly understood, I think the law and the private sector together help advance the protection of fundamental rights.
Absolutely. And just looking at, apologies, looking at the history and what's at the table right now in terms of AI, I would kind of would like to shift the conversation to some of the current developments and current some of us and all of us maybe are working in. We have, starting from 2019, the OECD AI principles, currently the EU AI Act being discussed, Council of Europe drafting the AI Convention. Last year, around this time, UNESCO, 193 countries adopted UNESCO's recommendations on AI. And only last week, here in US, we've seen the launch of the blueprint for an AI Bill of Rights. So there are now multiple frameworks that we're discussing, seeing convergences and divergences across the many. And maybe starting with one of those, Thomas, if I can start with you, can you give us a current status of the work of the Council of Committee? And obviously there are some developments that have hit the news as well. Maybe if you can give us the current state and what you see as the future of the work.
Yeah, yes, thank you. Sometimes your voice is a little bit breaking, so I hope that you all can understand me. If not, let me know. Well, the Council of Europe, for those that know it, is an intergovernmental organization where now 46, almost all, with 2 exceptions, basically members of the countries of geographical Europe are members. It's more comparable to the UN than to a supranational institution like the European Union, because it's developing standards and on 3 pillars. One is democracy, the other one is human rights, and the third one is rule of law. Three elements of what we consider like basic values of European values for free societies that are interlinked. And this is, let's say, the unique one of the unique features of the Council of Europe, that it is with this structure, it is actually possible to develop regulatory frameworks or legal frameworks that are coherent with these 3 regards. And it has, as I've said before, it does have a court where every citizen in a member state of the Council of Europe can challenge a decision or an action by a state in order to make sure that his rights are respected. So this is the bigger general framework. And the Council of Europe has already in the past few years developed a number of instruments regarding artificial intelligence. So there has been soft law on the use of AI in the judicial system, on AI data protection, on algorithmic systems impact on human rights in the digital world in general, or more specific with regard to freedom of expression and the media system. So there has already been sectorial work at the Council of Europe, like others have done, the OECD and so on, in this regard. What the committee that I am currently chairing is now doing, it has the mandate to develop a transversal instrument, an instrument that is applicable to all development, design, and application of AI systems based on the Council of Europe's existing standards on human rights, democracy, and the rule of law. So it's trying to develop, and like we have the Convention on Human Rights, something that is actually close or close to the level of principles like the ones you have in the Human Rights Convention, but with a specific focus on AI, but general enough so that it's applicable to all uses of AI in all sectors. And the important addition to what you to developing such a legal instrument is that this instrument should be conducive to innovation. So it's not meant to hinder economic or social progress. It's meant to be favoring and fostering such progress, but within a framework that respects the fundamental rights of democracy, human rights, and rule of law. And it is also, again, meant to be complementary to instruments that are more specific, that go more into detail in a particular sector, be it the use of AI in the health system or in education or in the automotive industry or whatever. So it's meant to cover the principles that should be applied to all applications that should not be then in contradiction to what you develop or what the Council of Europe or other institutions on national levels may be developed with regard to particular sectoral instruments. And so in June this year, it has been decided by the Committee of Ministers that these legal instruments should have the form of a binding instrument of a convention. Whether this will be called convention or framework convention is something that is still under discussion. But the idea is that it should be general enough that it can be applied and transformed and respected in legal systems with a certain variation. So it's meant not just to be an instrument like the AI Act of the European Union, that is, of course, a legislative piece that is applicable to 27 member states. It's meant the Council of Europe's, the hope that we have is to develop a convention that is actually of a global reach, that also countries that are not part of the European Union or not even part or members of the Council of Europe may also sign up to, and thus helps to establish a global standard on a principle level on the development, design, and application of AI. So we also do have a number of countries already now participating in the work of the committee of the CAI that are not from Europe, that are not members of the Council of Europe, but observers, and they also work together with us on such an instrument. So this is an important, I think, expectation of all participating, that whatever we develop may be useful as a global guidance and not just for the member states of the Council of Europe. So where we stand now is that we do have, we've had 2 plenary meetings now, the last one a few weeks ago in September, end of September. We do have a 0 draft, which is basically, it's not the first draft yet, it's a 0 draft. This is how we call it, in order to show as an example to the members and observers what could be the elements of such a convention, what are the principles, what is the level of abstractness or the level of details that such an instrument reasonably should have. And then a second important element of this is something that we call HUDERIA. It is human rights, democracy, and rule of law impact assessment that should actually help then countries that sign up to this convention to basically to implement this and create also some guidance and clarity about how to measure impact, how to decide when a risk or an impact is of a kind that action is needed. And of course, there are several layers to risks. We also know, of course, that the draft AI Act that is around is also based on a system of classifying risks. And depending on how high the risk of an application is considered, then there's different consequences or different measures that need to be fulfilled. So there's a similar logic, although we try to put the stress, maybe compared to the EU AI Act, a little bit less on an ex ante risk assessment, but a little bit more on a ex post impact assessment. Of course, knowing that if you do these assessments regularly, of course, the impact assessment of past experience turns into the risk assessment of future experience. So of course, may also grow together. But this, what we are trying to do also there is not to develop a detailed impact assessment, but we are trying to develop a model for a methodology for impact assessments on human rights, democracy, and rule of law that contain elements that then leave some marge de maneuver for the individual countries then to develop their own concrete mechanisms based on this model. And so the HUDERIA that we are currently working on, and we're doing this in cooperation with the Alan Turing Institute from the UK, is based on 4 elements. One is context-based risk analysis, what we call COBRA, and the notion of context-based is extremely important because the risk depends greatly of every application of every AI system depends greatly on the context in which it's been used. The next thing is a stakeholder engagement. So that means that there is a debate about these risks, how to avoid them. Then there is the actual Huderia that follows should follow a number of parameters. And then the next step, of course, is because you do not prevent, if you try to prevent every risk from happening, life would not be possible. We would not be able to drive cars. We would not be able to have to use airplanes, but we would also not be able to exercise rights like freedom of expression, because rights are broken daily. The important thing is that there are remedies or risks turn into actually accidents daily. The important thing is that there are remedies that you can use in case damage is occurring or is risking to occur, so that then, of course, people learn, and the industry, but also citizens learn from their past experience in order to minimize risks or reduce impacts. And so we've started to develop the key elements of this Huderia model. And I stop maybe just saying one thing. Of course, the easier part of this this instrument is the human rights part, because at least in Europe, but also on UN level, we do have a legal system that allows courts to decide to what extent a human right has been infringed, or to what extent, if several rights apply and that may be in conflict to each other, where to draw a border, which right is predominant in a particular case, whether it's the right to freedom of expression or the right to protect the integrity or the privacy of a person. So we have a very sophisticated legal system that is able to deal with human rights. As it has said in the beginning, when it comes to democracy, it is a little bit more difficult because there's no legally agreed, let's say, notion of democracy. We do have a number of varying systems that we call democracies, or we tend to call democracies. So it is a little bit more difficult to then develop a binding instrument that is supposed to protect and foster democracy. But you can actually deal with these elements, at least to some extent, by deriving proxy rights that are elements that hint at a level of democracy. And so we are also working on this. And of course, rule of law is about separation of power. It's about remedies and so on, and transparent processes and so on and so forth. So this is where we stand. We have these two parts. We have a zero draft of a convention that outlines the basic principles. And we do have a model of a Huderia of a human rights, democracy, and rule of law impact assessment that we are developing, and that we'll share with the members and observers of our committee very soon to discuss it then in more detail in January. Thank you.
Thank you, Thomas, for those details. For those who are not obviously zero draft being not public, there will be more to come. I will say watch the space. But before I go to the other panelists on the Council of Europe work. There's been, you mentioned the global reach and global impact of Council of Europe conventions, and also the fact that its complementarity to other frameworks, especially EU AI Act, as it is being discussed now. Council of Europe has more member states, as you highlighted, than European Union. But there is discussion now, as has been in the news as well, that EU is looking to be a party to the convention and taking on some of the discussions. Can you, to the extent that it is possible, where you stand, can you provide us with some like status on that? On those conversations with EU and Council of Europe?
To whom is this question addressed? To me or
to you, and then I would like to go back.
Okay. Well, I mean, this is basically the question in the EU is given their legal division of competencies between the European Commission and the member states, is who is actually having a mandate to do what in intergovernmental institutions. And this is not up to me to comment about how the European Union organizes itself. It is obvious, and I think understandable, that institutions evolve, that there are new situations, that competences are moving or developing. So the important thing for us to note is that everybody present in Strasbourg, the European Commission, all the member states of the EU, all the member states of the Council of Europe, all the non-member states of the Council of Europe that were present, everybody agreed that it is important, it is crucial to develop such an instrument of the Council of Europe with a hopefully global reach, and that everybody is fully committed to participate constructively in this work. That's also been mentioned by civil society organizations, by businesses that have been present. Everybody agrees that there is a value added in having such an instrument. And then again, the procedural details of institutions within them is something that is not up to me to comment. What is important for us is that everybody is willing to clarify their internal open questions as quickly as possible, and that we have found a way that we can move on with our work, and we do not have to pause, and nobody asked us to pause. So it's we are moving on and working on these two elements that I've mentioned, the convention itself, but also the hood area model. And yeah, so that is the important message, that everybody wants this work to be done. Everybody wants this work to progress, and everybody's convinced that there is definitely a need and a value added in such an instrument. Thank you.
Thank you, Thomas. Mark, Angela, I would like to come back to you on importance of Council of Europe Convention as representatives of civil society. Where do you see the complementarity and the importance of this work moving forward?
Following Thomas's point, I think your word, Merve, of complementarity is a very useful way to understand the relationship between these two legal instruments, because of course the European Union and the Council of Europe have different mandates, they have different memberships, but I think the pieces could actually fit together quite well, with the AI Act focused on the risk-based management in terms of the internal market, and the Council of Europe AI treating speaking globally to the three pillars that should be supported in the context of an AI treaty. So complementarity is a good word, and I think it's the right way to see the relationship.
Thank you. Angela?
Yeah, I mean, not much to add to that. I think it's important to stress these are just two things with different purposes. So the three pillars for that Mark just mentioned, that the mandate of the Council of Europe is based upon, for those who don't know, it's human rights, democracy, and the rule of law. And that's, of course, a different approach that the EU takes when it's with its AI Act focused on market harmonization. And I think that's why they should be really complementary to each other. I think there's also a big chance in them being so. And that's also why we, as civil society observer organizations, have been stressing or are stressing that the EU process should not delay the Council of Europe process. So it's great to hear also what Thomas just stressed, that this will not be the case, because they're just two different things. Of course, you cannot ignore the fact that they are developing in parallel and, of course, influencing each other. What I think you can observe in the AI Act, on the AI Act in general, is it has this agenda setting character. So the topic climbed up the agendas in many other jurisdictions, I'd say, including Switzerland, but also a bit the standard setting character. So the implicitly, like the AI Act has set a certain benchmark that others now sometimes adopt or even feel the need to justify if they depart from it, and so on. So this is understandable. And I think also in the Council of Europe negotiations, it's sometimes hard to think outside the box and forget about the AI Act, because it's just a thing that's out there, black on white. But I think still think it's important to remind us of the different purposes of different political processes. Yeah, thank you.
Thank you, Angela. And you're right, for those of us heavily involved in EU AI Act and the modifications, we've been living and breathing it. And the 3,000 plus amendments didn't help to kind of think outside the box, to be honest, to kind of step away. But Celine, I want to go back to the OECD's work on this context, and OECD has pioneered the AI principles, some of this work back in 2019, obviously the work starting before that. As we are looking at these different frameworks and regulatory instruments being developed, can you tell us some of the lessons that were learned from that OECD process?
Sure, Merve. Thank you. And listening to the live conversations that are happening now around emerging regulations, to take us back 4 years in the world of AI seems like a lifetime ago. So, indeed, as you mentioned, in 2019, countries came together and published what was at the time, they adhered to the first intergovernmental standard on AI. And now, as we've discussed, we have the EU AI Act, the Council of Europe work, UNESCO recommendation on AI, and others. So 4 years on, if you will, or nearly 4 years on, perhaps the most important impact of the AI principles, I think, still has been to raise general awareness of the importance of this technology and to support governments in their efforts to keep pace. So, a theme that's come up in our conversation today is that often policy lags behind the technology, and this can leave policymakers in a seemingly, endless game of catch up. And what the vision was in the 2019 principles was to cast a light, what we saw as the OECD as an emerging but really fundamental challenge to countries. So, the emergence of AI. And the principles emerged at the cusp of what was an AI surge, or summer, as we call, it goes through these cycles of summers and AI winters. And the principles aim to reflect kind of the most important values that AI systems should embody. And so if we talk about kind of lessons learned and impact, the principles are now becoming a standard part of AI regulation and policy around the world. And, they've kind of paved the way for this significant policy advancement. And so, for example, again, if we go back to, let's say, 2016, when experts gathered and started doing this work, only a handful of countries in the world had national AI strategies. Now, zoom to today, and you can check this on the OECD AI Policy Observatory. We, on our database of national strategies for AI, now more than 60 countries and jurisdictions have produced over 800 related AI policy documents. So there's been this kind of explosion of discussion and strategic insight and best practices with regards to AI. Another kind of difficult and lesson learned is around the definition. So how do we define this technology, something that is so quickly moving? And it's still a very live debate that we're seeing play out in various forums around the world. How do we strike that balance between having a definition that is useful, but also that offers the space to capture how this technology might evolve? When we look at, the general applicability of AI, we look at general AI, general intelligence, and, given that policy lags behind, we had a difficult time providing a definition, but we did one that would stand the test of time. And what we see now today is that the 2019, the definition in the principles is actually being used and is a basis for many instruments around the world. So if you look at the US National AI Initiatives, work with NIST, so the National Institute of Standards and Technology in the US, and the European Commission. But I guess I'll close my answer by saying, writ large, what is key here is interoperability between AI governance instruments. Countries can arrive at different policy solutions for AI governance, but they must be compatible. And what we want to avoid is this bifurcation of AI rules globally, which could result in forum shopping or regulatory arbitrage, for instance, where gaps or considerable differences between AI definitions or regulations could cause harm or even competitiveness challenges challenges to reaping the full economic benefits of and potential of artificial intelligence. And we know that this is a hard thing to do, and absolute harmonization between countries is impossible and probably not necessary. But it doesn't mean that these approaches should be disjointed. So really just to emphasize that the timing now is really critical, because AI laws, regulations, and standards are currently being developed. So it's great that we're talking about this and having a dialogue before these laws and regulations get baked in. And the OECD really aims to facilitate this interoperability by being a forum to bring together countries and organizations from around the world. So maybe I'll stop there. Thanks, Merve.
Thank you, Celine, and thanks for sharing the experiences and the lessons learned as well. And you're right. I mean, you made a great point on regulatory arbitrage piece, which kind of gives me a great segue to my next question on red lines and how to avoid that regulatory arbitrage in certain instances. Can we have red lines that applies across the board globally, that is in all of these instruments, so we avoid that? And Jean-Marc, maybe I start with both of you on that, and maybe Marc, start with you on the red lines. What do you see as more established red lines or more accepted ones, and what do you see as we still need it and maybe not necessarily discussed enough across these instruments?
Well, I know a lot of individuals and organizations have strong opinions about various red lines. To me, what has been most fascinating, and to build on Celine's earlier comments, is to watch the evolution of the red lines in the context of the AI policy instruments that the governments are adopting. And so, for example, in the OECD AI principles, I don't think, in fact, we have any red lines at all. There were some red lines proposed in the earlier universal guidelines for AI, but that's not a formal document of governments. But then you fast forward to the UNESCO recommendation of 2021, and you see two clear red lines. One is on the use of AI for mass surveillance, and the other is on the use of AI for social scoring. And that's a recommendation now that's been endorsed by 193 countries. And then, of course, we move on to the EU AI Act, where there's a very fierce debate over which AI applications should be considered high risk and which AI applications should be prohibited. And finally, if you look at the national and local level, you see many efforts, in fact, decisions to prohibit the use of AI for facial recognition in particular. So I think you can say objectively that as you look at the evolution of AI policy, as the public and policymakers begin to understand more about the full impact of AI, there's a greater willingness to adopt and to implement prohibitions.
Thank you, Marc, for giving us that extensive view of different instruments. Jean-Marc, what do you see as more now consensus build or accepted red lines, and from your perspective in both policy work and corporate work, as what else that needs to be there?
Yeah. Well, on the corporate side of things, it was quite interesting a couple of years ago to see in particular the actions taken by some companies on the issue of facial recognition in particular. So I won't go through all these announcements, but I think that was quite an interesting moment. Of course, in a specific context back then, but I've rarely seen something like this from the corporate world in the space of a few months' time. All these announcements about stopping to provide tools or AI systems on facial recognition for some purposes in some cases. So that was quite interesting. On the government area, so I'm looking specifically at the EU AI Act, of course, and like Marc said, from the original draft of the Commission or of the European Commission already, you do have banned practices where, because this is a risks-based piece of legislation, some risks are seen as unacceptable. Mark mentioned a couple of them which have made their way into the AI Act as well, social scoring, for example. But I think there's 5 at the moment. But it's a very lively and difficult discussions. There could be more. There could be less if you look at what national governments are saying when we're addressing issues like national security. But so the point is, you have a list of banned practices, and you also have a list of areas where the use of AI is considered to be high risk. So these are clear red lines. Do we need more? Do we need less? I don't know. I'm not a huge fan of lists, to be honest with you. I think what matters more is, that we have in those initiatives by governments or those pieces of legislation some clear definitions and guidelines to conduct those risk management processes in the future. Because AI is so use case dependent that I think it's absolutely impossible in a lot of times to cast in stone right now what the exact uses will be and if they are high risk or too risky. So that's why I quite like the approach by the Council of Europe or the OECD. It's flexible, and I think that's what we need, because this technology evolves very quickly. And you need legislation that can adapt to this evolution at the same time, or else it becomes obsolete and maybe problematic quite quickly. And then what do we do? Do we want to have a revised EU AI Act in 5 years' time? Someone mentioned 3,000 amendments in the Parliament. Are we going to have that again? I don't want to compare this with the case of the GDPR, but you can't reform GDPR. I'm not saying that there would be a need to, but then you're stuck with something that may not stand the test of time. So banning and lists in general, I'm not sure it works all the time.
Okay, what I'm hearing though is there's definitely a need for some red lines for unacceptable as is, but clear guidelines and a methodology to add or either moratoriums or bans in the future as these technologies develop and emerge. Thomas, I would like to hear from you on this red lines as well.
Yes, thank you. And just to follow up about what Jean-Marc has said, what we are witnessing now is there's basically a tendency that some applications that are considered very high risk or too high risk, there may be red lines, but then there may be also be red lines to the red lines, i.e. exceptions to red lines. And again, it is very, very context-based. So for instance, most of the experts agree that emotion recognition through voice analysis or analysis of face movements is something that is very problematic and should not be allowed in many applications or many contexts. But at the same time, these particular applications may be extremely helpful in specific contexts, like for instance, with in the medical environment, with people that are not able to talk or speak or express their emotions through, let's say, traditional ways. That actually, if you can analyze their state through using AI, that may be something that would actually be in their interest. So, like it has said before, I think the awareness is basically spreading that very rough black or white red lines may not make sense, but you need to look much more into the context of the application. And then again, you end up with some general maybe red lines, but then a number of exceptions, or the other way around, you may have less red lines, but the number of contexts where you say, if this is the effect or the intention to use an AI system, then it should not be allowed. So it's very, very context based. And I think we need to if we want to really benefit from these technologies and limit negative effects, we need to be very develop a system that is flexible enough to even be applied to applications that we don't even know yet, but provide for a logic that allows us then to draw red lines whenever it is necessary, but maybe not list them in a too concrete way right now. Thank you.
Thank you, Thomas. Yes, somehow our society finds way to use it in unexpected ways as well. Like when you release a technology in the wild, it might come back with a boomerang in unexpected ways. I'm kind of also mindful of time, and I want to leave some time for questions from the audience. But before I do that, Mark, I cannot finish my questions without asking you about the AI blueprint for AI Bill of Rights, which is the most recent development in the AI policy landscape. What do you see as the blueprint doing, and maybe what it needs to do, or what should be the next steps using the blueprint? Can you give us some context around that?
Well, there's been a lot said about the blueprint for an AI Bill of Rights, and I think the most helpful way to understand this document is to think of it as a white paper, and as a white paper that could be extremely influential. I know some people were disappointed because they saw the phrase Bill of Rights and they were anticipating that there'd be an announcement of a big legal framework in the US, but actually that was never on the table. So if that's what you were looking for, you need to look elsewhere. But the contents of the report, I think, are actually very good. I think it addresses directly and on many levels emerging challenges related to AI bias. And if you contrast what we might say is now the US AI policy approach with some of the other AI policy instruments, you see clearly from the US a great emphasis on not simply fairness, but also equity and the need to address the embedded problems with AI. And I see this as a very important and useful contribution. The other brief historical point to make is that almost 50 years ago, there was a very similar report issued by a US federal agency called Records, Computers, and the Rights of Citizens. And that report also had a phrase, the rights of citizens, that created an expectation of a legal announcement. But that report was also a white paper. What's so interesting about the history is that a year after that report, the US adopted its most comprehensive privacy law in all of its history. So I see the AI Bill of Rights as a foundational document that could quickly lead to a comprehensive legal framework. And I think credit should properly be given to the Office of Science and Technology Policy for addressing this very important challenge of AI bias.
Thank you, and thanks for drawing that parallel. Sometimes we forget what happened, the achievements and the developments that happened in the past, and kind of think that we're inventing the wheel again and again. But going back to Thomas's first comments on we have working models, we have experience, and we have examples of regulation working in emerging technology very well, which is we take as granted at this point some of those regulations and couldn't think of a life without them. So definitely developing. Right, let me move with my next question, and I also trying to catch up on the chat. There's great conversations on the developments. At the very beginning, we mentioned, Mark, you underlined that regulation actually creates better innovation, that it actually fuels innovation. A lot of in this conversations in regulatory frameworks or even with self-governance methodologies, we see this approach trying to balance fundamental rights against economic interest or security interest. Maybe Angela, I could start with you on this one. Where do you see the danger of that balancing act fundamental rights on one hand and economic or other security interests on the other, as we speak of fundamental rights, democratic values, and rule of law.
Yes, thanks for that. And thanks also for closing the circle to the initial discussion. I think as someone trained in human rights law and theory, I'm very skeptical about the appropriateness of the word balancing here, because it's not something you actually do, balancing fundamental rights. It's not like one against many factors, because these are rights that carry special normative weight as protections of human dignity. So they essentially define and delimit actually the space of legitimate, at least state conduct, probably not only state conduct. So they set like the limits in everything a state does or does not do. But also I want to come back to what you just mentioned. I mean, it's not like economic and security interests on the one hand, or let's say innovation and fundamental rights are contrary to each other or should be weighed against it. Of course, it's clear that there are situations where where weighing occurs again. I mean, among different interests. I'd say leave fundamental rights out for the moment, but actually, I mean, the goal that innovation has should not be contrary to the goal that human rights protection has. I mean, innovation should also eventually just serve human interests, right? I mean, innovation is not a goal in itself. It is also does not have any goal beyond serving human interests. So I think that's important to say. We only want innovation that actually serves our interests. So in that sense, I don't think there's this a contradiction actually involved.
Thank you. I couldn't agree more. Jean-Marc, maybe.
Yeah, I agree with Angela when she says that, on the point she made on innovation, the problem is when you have, well, governments going ahead with a piece of legislation, as we said, which is I'm talking about the EU Act again, which really is a product safety legislation. It's very specific. If they start going this way and then go ahead with, again, lists, they will have to find a way to strike that balance, even if we don't like to have a balance or don't think that there should be or can be a balance between rights and what can be allowed on the market. They're going to have to now, and I mean, if you follow the discussions here, in particular, again, on facial recognition, I don't know how they will find that balance, to be honest. It's a very good luck to them. It's a very, very difficult debate. And I mean, you can see both sides of the argument. And with COVID behind us, we have another example, no matter what you think about that, but we've lived through a year or a couple of years where some of our fundamental rights, I would say, right to assembly, even right to freedom of speech sometimes were restricted because the government, maybe society as a whole at one point said, well, we have a bigger interest there and we need this balance. So we're going to restrict those rights and impose some new measures. It doesn't please everybody, far from it, but sometimes it's necessary. But I think the main issue right now with the act is really around security. So I don't have the perfect solution to this. There will be some form of a balance there that will come out of this act. Will it be the best ever? I'm not quite sure. That's why I always go back to legislation that is not written for eternity, because it's impossible. Everything is, in particular with AI, needs to be taken looking at the context of things, and this question here is no different to that point. So I hope they keep the context in mind, because the context evolves and is always different.
Thomas, let me finish by your comments. is there, what do you see as the context being different when we're talking about fundamental rights?
Yes, thank you. Just one word about this balancing of let's say economic progress versus human rights. I also would strongly agree that this is not an either or, but it is just a framework within we want economic innovation to happen. And to give you a very silly example, the fact that speed limits have been introduced, which are normally around in the whole world, apart from some German motorways around 100, that has not prevented the industry from keep developing cars with 1,000 horsepower that could do 300 miles an hour. The thing is, in a city, they are just whatever the horsepower of the car is. You are not allowed to drive more than 30 in a city, or 50 or 80 on another street, and it has also not prevented some people from buying such cars. So there is an agreement that in a certain context, a certain speed limit is appropriate, but that has not prohibited innovation. And now, of course, some cars are meant to be as economically or ecologically efficient. Others are meant to be sports cars that are supposed to have as much horsepower as possible. But also there, if they're used in the same context, there are the same rules that apply. They all need to have an airbag, and I don't know what kind of safety measures. But then again, if you're on a race, it is about driving as fast as you can. So again, it is very context-based, but I would really not see the main issue as balancing economic innovation and rights, but making sure that whatever is used, how that innovation is taking place in respect of rights. And again, this is very much context-based. Thank you.
Thank you, Thomas. Maybe continue with that, because there is a question in the chat for you. Let me read that one. What is the number/role of observers as they participate in the council's work? And what's the timeline for public consultation?
Yes, thank you. So if I may, by the way, something that I forgot is that actually the CAI, this current committee, is building on 3 years' work of its predecessor committee that was working for 2.5 years, that has produced the feasibility study with lots of analysis on the risks, on the challenges, but also on the good sides of AI and opportunities, and analyzing all kinds of self-regulatory, soft law and other frameworks, identifying gaps of what actually is it that is needed, and that all is the basis, and what could be potential elements of such a legally binding instrument. So our work is strongly building on that. At the last, and I've mentioned it already, that we have circulated the zero draft among all members and observers in the CAI, and this is the number keeps growing, but it's about 100 or so from not just Europe, but from other countries too. I have asked them whether they would want to share the zero draft with the public now. Then the committee has decided that they would not want to share this now, but that at a later stage, a draft should be shared, and there should be a public consultation. That will not be this year, but it will be sometime next year. And of course, this is not my decision as the chair. Again, this is the committee that decides. And so I cannot give you an exact date. By my intention is definitely, and I've communicated this several times inside and outside the committee, I want to be as open and as inclusive as possible, not just to governments, but also to all stakeholders, because we need the input and the experience from civil society, from businesses, from the technical and academic community, if we want to develop a framework that actually works, that functions, that is not just a nice piece of paper, but something that is implementable and that is also reasonable in the sense that people want to respect it, people want to implement it, then we need our collective intelligence of all stakeholders with all kinds of experiences. And again, I cannot give you an exact date by now, but the commitment is there that there will be a consultation on the draft at some point in time. I hope that is satisfying to the extent it can be. Thank you.
Thank you for that clarification, Thomas, and looking forward to it. And we have thumbs up from Mark as well. One thing I would like to, another question in the chat that I would like to go back to is from Mira Wolf, kind of going back to Angela's point that we shouldn't rely on corporations to self-regulate. Her question is, however, given that regulation always seems to be reactive rather than proactive, I wonder how the democratic institutions can eventually catch up to provide guide rails or guiding principles before undesired impacts of a given technology become apparent through their use. Angela, maybe I start with you and then go to Celine to hear also her comments on this question.
Yes, thanks a lot. I think it's a great question. And I also want to come back what was stressed by others, Thomas and also others. I mean, it's not that this is, I don't know, a lawless space right now in which companies develop technologies or use technologies. And this is also why we don't, what, for example, the Council of Europe right now does is not developing a new, call it AI Bill of Rights. I find the title misleading too, because we actually have bills of rights and we have rights, but they need to be, we need to make sure that they are also adopted and interpreted so as to also be adoptable to algorithmic decision-making, for example. So I think that's like a very general remark that I think is important to see. We need to make sure that we interpret existing laws accordingly, that we enforce them. And of course, then we can see where we need further norms to develop and evolve to respond to certain challenges. And on Mira's point specifically, I think that's also why we need to make sure that we have access to accountability frameworks. For example, that if we are affected by a decision that is made by an algorithmic system, that we have access to information. First of all, that we know the decision was taken by such a system, but that we also have rights to explanation and so on, because these are actually the preconditions of having access then also to legal remedies. I cannot defend myself if I don't know what happened. So all of these frameworks that actually guarantee control and also accountability, these are very important because, of course, the aim is not or cannot be actually to prevent all possible harms. There will always be such harms, but then that's why we need such accountability frameworks. Another point I'd quickly like to make, also in response to a very similar question by Joanna. Yes, I think, for example, in our view, case-by-case impact assessments for users of systems are also a way to guarantee transparency, control, and then also lay the ground for accountability. Of course, they cannot guarantee that no harm will ever occur, but these are instruments that allow us to actually have scrutiny over the use of these systems. And I think that's an important precondition for accountability too.
Thank you, Angela. Celine, can I continue with that on the same question that was asked about?
I'll make 2 quick points in the interest of time. So first, just to reiterate a comment that I had added to the chat. A way that governments and policymakers can kind of avoid this catch up as the technology evolves is, it's really hard to get it right with a big kind of law. Hard law can be very tricky for many of the reasons we've discussed today. So a tool that can be used is regulatory experimentation and an iterative approach. So, something that has emerged as a tool are sandboxes. This, I think, offers really interesting potential to apply to AI, especially as it's a general purpose technology. It allows you to kind of, play in a sandbox from a regulatory and consumer protection perspective in a specific sector. We've seen it, kind of arise in the UK with the fintech sector. So there are certainly lessons to be learned in the spirit of not reinventing the wheel and learning lessons from other regulatory experiences in other sectors. And the second point I'll make is the need. This is going to be a very OECD comment. It's the need to have an evidence base. So, not to really look at, have harms materialized, and are these real risks, or are they perceptions of risks? And so one thing that we're working on at the OECD is to build a tracker of AI incidents. So these are concrete, it's a proxy, we're using news articles, but to the extent possible to try to see where risks or near or incidents or near incidents have materialized, and to feed that into the risk assessment and mitigation model as well, that feeds into the classification of AI systems for really a harmonized approach to risk management. So I'll leave it there. Thanks.
Thanks so much, Celine. To your point, in the interest of time, we have 3 minutes. I would like to do a round robin. 1 minute final words for this panel before we go on to break. And let me start with Jean-Marc. What will be your final word as we're looking forward to these regulations and developing frameworks?
It's a wish, Merve. We talk about AI all the time in such negative terms, and I'm a bit sick of it, to be honest with you. AI can do a lot of great things as long as we keep controlling it serves us, and I think most people agree with that. So I'm having so many conversations where we talk about dangers and risks and damages, and can we talk about AI in a positive way as well? That's my wish.
Thank you for that. Thomas, what is your wish or final word from this?
Well, my wish is that we actually will be able to agree on a framework that is as global as we can, because as you know, we do have some differences between countries in their legal system and their tradition. So so I hope that the common denominator is strong enough that we actually get something that is guiding, at least for, I don't know, much more than 50 countries. Thank you.
Thank you. And I hope that our respect for human rights and rule of law and democratic values are strong enough to guide us that and demand that as well. Angela, what's your wish list?
A bit to counter the narrative.
Not the whole list.
Not the whole list. Okay, I start. I think to counter a bit that narrative that tech development and us being affected by it is like a force of nature that we can do nothing about it. I mean, not that tech development will happen, and that is great, of course, and we can all benefit, hopefully, eventually from it. But we are actually the ones who decide how to use it and what are the conditions, how to use that technology. And I think that's, a bit that we all have that idea of turn the tables. We're the ones deciding on the conditions in which we want to benefit from these technologies. And last wish, I hope we'll get more voices at the table in discussing these governance frameworks. Thank you.
Thank you so much, Angela. Celine, what is one wish from your end?
Sure. So many good ones. I second what's been said. I guess to complement, I think it's that to remember that behind these regulations and laws that we're all discussing now are people. I think that it's come out in the conversation, taking a human rights approach, but just to remember that, this technology should serve to improve the lives of people and not the other way around. I think we've all, a little bit felt like perhaps slaves to Zoom over the pandemic, but just to really remember the human aspect that, in these discussions, ultimately that they aim to serve. Thank you.
Thank you so much. Mark, what is your one wish?
My one wish is that our technology, our innovations, our future reflects our values and helps create the world in which we wish to live. I think this is a real challenge. I also think it's a little naive to imagine that this will happen automatically. If we look at the world today and we look at the impact of industrialization, we can see, prosperity for some, and a climate, and a country and a world that's almost on the brink. So it's a real challenge and there's a real opportunity, but we need a sense of success where technology creates the world in which we want to participate, and we have helped make that future possible.
Thank you, Mark. And that very much aligns with my one wish, that we, instead of firefighting with these technologies and the harms and the impacts, that I wish we have the time and space to imagine what that future looks like and actually build technologies towards that rather than trying to control some of the harms and our values and rights. With that, I want to thank all of you as my esteemed panelists, but also esteemed attendees. Thank you so much for your contributions, your great insights. It's always an honor to have these conversations with you, and looking forward to more conversations. The next session is going to be a 15-minute break until the top of the hour. And at the top of the hour, Christina Potnar is moderating upon. Again, thank you so much for being here today and for all your insights.
Thank you.
Everyone.
Thank you.